Welcome to Closely Held Business Review. We're going to work on Module 3. Today. We've done agency and partnership, and now we're going to talk about limited liability companies. And I love to talk about limited liability companies because here's where the rubber really meets the road. In modern times, LLCs are quickly becoming the most popular type of business entity because they're highly flexible, they provide limited liability, a variety of different tax benefits, and for our purposes, one thing that's helpful for us lawyers is they need to be carefully drafted in terms of their operating agreements. There are so many ways you can modify an LLC and so few mandatory rules about them. And the default rules are not always very clear. So here we are really talking about understanding how to draft an agreement. And for me, that's the most exciting thing for lawyers to be working on, is when an agreement really needs careful drafting. As a reminder, I'm Professor Seth Oranburg, teaching electronic discovery, closely held business, and corporations here at FSU. Previously practiced venture capital transactions at Fenwick and West, and I work on mergers and acquisitions, venture capital finance, and general startup advising. So let's get started with LLCs. LLCs are not a corporate business form. A corporation is a corporate business form, but you might be surprised how similar LLCs can be to corporations. You can make one that looks a lot like a corporation, but you can also make one that looks a lot like a partnership. And as a result, we talk about these as very flexible entities. Members, we talk about members in a limited liability company. We have members, and we may or may not have managers, but the individuals that participate are the members. They have limited liability and the ability to participate in the business, which distinguishes them from limited partnerships, in which the limited partners had limited liability but not the ability to participate in the business, and the general partners had unlimited liability but could participate in the business. This is also slightly different from LLLPs, where the general partner has limited liability and can participate in the business, because there we still have the limited partners. The relationship between the members is central and is codified in the operating agreement, or the LLC agreement, or the limited liability company agreement. That is the most important document when it comes to understanding the governance of an LLC. But here we're going to talk about some of the default rules. The first LLC Act came about in Wyoming in 1977. In our state of Florida, we were second. We had one in 1982. But LLCs did not really come into their own and become a major business entity choice until Delaware adopted them in 91, and through 95 and 97 amendments, some would say maybe perfected them, or at least brought them to the status of being the most popular state of incorporation for yet another type of business entity. Although, in fairness, because they are closely held and they often do not have outside investors, you will find more LLCs formed in the state in which they operate than Delaware corporations, because Delaware corporations often choose Delaware because it's more comfortable for investors. But we do still see a lot of LLCs formed in Delaware and operating in other states like Florida. Why do they exist? Well, they really came about because people were coming up with very creative but very complicated and expensive ways to do real property transactions. Real property transactions have various tax issues that are beyond the scope of what we need to discuss, but there are losses and there are gains, and it's very helpful for the investors to be able to take those losses and apply them to their other projects. So they wanted to have these flow-through benefits, but they also wanted to run the business. When we talked in Module 2 about limited partnerships, we have one limited partnership case where the limited partners lost their limited liability because of participating in the use of real property, in the management of it. That would not happen here. And why not corporations? Well, corporations don't allow that pass-through, with the exception of an S corporation. We'll talk about why they don't work for a lot of people. And partnerships require unlimited liability for actively participating partners, except in some 19 states that has a more modern law where limited partners never have liability, but you still need a general partner. LLCs, you don't need to have that element. So the LLC provides this new solution for a very flexible arrangement. They can be member managed or manager managed. We're going to go into detail. That's really the most critical decision in structuring is member or manager managed. And they can be flow through, meaning the taxes are paid directly by the members, or they can have entity-level taxation, similar to corporate taxation, where the entity itself pays a tax bill. They also do not have to observe as many corporate formalities as corporations do. And just as a reminder from those who have taken corporations or are interested in it, if corporations fail to observe corporate formalities, the directors could become liable personally for the debts and torts of the corporation. So having fewer formalities helps preserve limited liability. There are fewer things to go wrong, fewer deadlines to miss, fewer meetings to fail to have, etc. Again, they're quite modern. They really came about in the 90s as a result of Delaware really promoting this very user-friendly statute. And they're very complex. So I love to teach about them. I particularly love to work on them because there's just so much there. Each case is unique. Each LLC is set up a little differently. There are very few that are just governed generally by default rules. And so whether or not a member is liable can depend on a great many factors. But this also makes it hard for the student. Makes it hard for the student because there just aren't as much, there's not as much case law, there is not as much certainty, and there are fewer governing principles I can tell you. We have 100 years of corporate law, dating back to, in Delaware, 100 plus years of corporate law, which we can point to and say, here's where we have director liability, here's how we have a shareholder derivative lawsuit, here's when demand is excused. But we don't have that when we talk about LLCs, and that's frustrating for the student. But what we can talk about is how to make these default choices, how to structure these entities, what are some default rules that we can waive, that we can't waive, and some considerations that permeate. So before we do that, one question that is probably on all of your minds, why not S corporations? It's on my mind, right? So recall that S corporations are a corporate structure where you get flow-through tax. So why not just use that structure? Why was that not good enough? That solves the tax problem, right? Well, not exactly. Couple issues with that. First off, non-citizens cannot hold stock in an S corporation. If a single stockholder becomes a non-citizen or transfers to a non-citizen, the S corp status is therefore lost immediately. Poof. You're limited to 100 shareholders who can only have one class of stock, which gives you limited options for your governance. Your pass-through losses, which some people, you want those losses. You want those losses because you can offset your other assets. They're limited to your basis in the stock. So you don't get the benefit that those real property investors want. They want to pass those losses through to offset their other gains. There's corporate formalities, which again, if you fail to observe them, may result in liability. And there's public disclosures that are required. You have to actually report who are your officers and directors. You may not want to do that. LLCs give you more privacy. So if any of these fit your client's description, any of these are problems for your client, the LLC may be the better entity selection for you. So what documents are required? Well, again, the operating agreement is the most important, but we also are going to file a certificate of formation to create this entity. It's going to be filed in the state that it's going to be incorporated in, not necessarily where it does business. You may have to then qualify to do business in another state. If you have investors, they might get a investor's right agreement, which sets out their rights. And that investor's rights agreement is sometimes rolled into the operating agreement. It makes the document longer. And often they will buy those equity units. They're called units. It's like stock. Units are like stock. You should think of them like stock. It's a piece of an ownership in an LLC. And they often buy those units through a unit purchase agreement if they're investors. And there may also be a management agreement. If it's a manager-managed LLC, there could be a side agreement between major investors and the managers about how the managers have to run the business and whether or not the major investors have rights to attend the manager meetings or inspect books and records. So let's talk about what choices we make at the outset. And as I mentioned, there's sort of this matrix. We have managers and manager-managed and member-managed LLCs. That's one axis. And we have entity taxation and flow-through taxation. I will say this, the manager versus member-managed governance structure is more important and has a bigger consequence. Whether you're a flow-through or an entity taxation, clearly that matters from a financial perspective, but most business people choosing this structure are choosing it for the flow-through nature of it. It's not very common to find the taxable nature. And in terms of if you make a wrong choice and have to restructure, It's easier to restructure from a flow-through entity to a taxable entity than from a taxable entity to a flow-through entity. Because you go from a taxable entity to a flow-through entity, what happens to that tax liability? Where does it go? And so it might have to be paid at a certain time, so it can be harder to structure in reverse. But still, we want to make these decisions at the outset. We want to make them right. So let's talk about our tax options. When I say flow-through tax, I mean that members receive a K-1 statement, and they pay profit, LLC profit, as their ordinary income, as if that share of their profit flowed directly to them, regardless of whether or not those profits are distributed. This can be an issue because, remember, the LLC is a separate entity. It's got its own bank account. It's got its own tax identification number, its own employer identification number. The profits come in, they go to that bank account. They don't go into your pocket. But the tax bill goes to your home address. How do you pay that tax bill? Unless you have negotiated to get distributions from this LLC to pay that tax bill, you may have something called phantom tax. And phantom tax is a tax you owe on money you have not actually received, and for that matter, may never receive. So one issue that comes up in flow-through entities is this issue of phantom tax. One benefit of these LLCs, though, if there is not profit but loss, all of that loss flows through to the members. And it flows through based on their ownership interest or however it's set up in the operating agreement. On the other hand, you can elect an entity tax treatment, in which case you will have something called double taxation. The way this works is that the entity, the LLC, will get a tax bill. Let's say the LLC makes $1 million. And it has to pay 35% corporate taxes. Yeah, it's $350,000. So we have $650,000 left in the bank. So when the partners get that distribution, they get the result of they get whatever their share is of $650,000. And then they're going to pay tax on top of that. Now, they're not going to pay ordinary income tax. They're going to pay capital gains tax on those distributions, like a dividend. Like it's the same tax if they got a dividend from a corporation. But the tax will end up being higher than if they simply received the money directly and paid tax on it only once. So there's going to be less money left over. Why do this? Well, if it's important that the losses stay with the company, because you want to offset those losses in the future, there are certain operating models where this makes sense. But again, most people are choosing the structure and not the more conventional corporate structure because of the flow-through benefit without the S-corporation limitations. So we don't see this as often. On the other hand, we have a multitude of reasons why you may choose either a member-managed or a member-managed LLC. This may be the most difficult choice, and it's probably the most important choice for the lawyer to help counsel and to set up properly so the governance functions as expected. Member-managed LLCs have three characteristics. They operate like partnerships. The members are similar to general partners in a partnership with limited liability, or general partners in an LLP without necessarily the additional investors, but there could be additional investors. In fact, unlike the S corporation where you have one class of stock, in the LLC, the member-managed LLC could have Class A members, Class B members, Class C members. The sky's the limit with how you structure these things. You can come up with all kinds of creative ways to do it. You could have a member-managed LLC, but you have a Class A member who has all the rights, and Class B members who have no rights. So you could structure things that way, and that effectively looks like, as we'll talk about in a second, a manager-managed LLC, but it's not. Yeah? You could have a manager-managed LLC where all the members are managers. And you can create all kinds of different structures. So it's important to really get your head around some of these concepts and then think very creatively with your client about what structure is going to suit their business interests. But we have some default rules. As a default, the members control the company. Right? There are no managers, so the members have to control the company. And as a default, each member has equal control rights. So if you're a stockholder in a corporation, what voting rights do you have? You have one vote per share, usually. Well, if you are a member in an LLC, one person might invest $1 million, have 1 million units. One person might invest $1, have 1 unit. Of course, with almost all these things, you can structure the operating agreement differently. But the person who invested $1 million, the person who invests the $1, will, under the default rule, have one vote each, equal control rights. Members are not agents by default unless the operating agreement gives them actual authority or course of dealing, or they agree. But they may have apparent authority. So we go back again to Module 1. What is a parent authority? A parent authority is a manifestation by the principal that creates a reasonable belief in a third person that the agent has authority. So parent authority would be when the third person reasonably believes, based on a manifestation by the LLC, that the member has authority to bind the LLC. In the ordinary course, a majority of members make decisions, but for extraordinary events, we need unanimity of members. And one extraordinary event is amending the operating agreement. They have duties to each other. They must discharge their duties with good faith and fair dealing. The concept of good faith and fair dealing is a contractual concept, and LLCs are creatures of contract. The operating agreement is a contract. All the members will sign it. When you sign a contract, what do you owe to your co-contractors? You owe a duty of good faith and fair dealing, and that's found in all contracts. It's also found here. They also owe to each other a duty of loyalty, but they're fairly limited duties of loyalty. And remember, they're not agents unless they have a parent authority. So we don't have some of those agency concepts here. We did for partners. General partners in a general partnership are agents. We applied agency law to think about their duties. But members in LLC are not agents. So we don't use agency law. We only have this much thinner veneer of LLC duties. What are they? One is to act as a trustee for any benefit received. So if the LLC is in the business of owning horses, and a member goes to the barn and exercises the horses by renting out the right to ride them, this benefits the LLC, so there's no harm done. The horses needed to be exercised. But this member has just received a benefit by virtue of the LLC's property, which is not his property or her property, but the LLC's property. So this person has become a trustee. The money went into their pocket. It looked like their money. It's in their pocket. But in fact, that money is the money of the LLC. And the LLC does not have to take a court action to get it. They say, hey, trustee, pay me that money which you received on my behalf. They have to refrain from taking an adverse interest to the LLC. And they have to refrain from competing with the LLC before it's dissolved. So in a member-managed LLC, the members cannot be undertaking related other businesses. We'll find that that's different in a member-managed LLC, and this can be waived. Now, there's also a duty of care. We're going to talk about the business judgment rule, which is a corporate law concept. We'll get to that in a few more slides. But we have that presumption that decisions that are made, deliberate decisions that are made in the course of performing the LLC's business, made with care, of a person in a like position, with being reasonable but expected in the circumstances, and with a reasonable belief that they're acting, subjectively believing that they're acting in the best interest of the company, those decisions will be protected and courts will not interfere with those decisions. Yes, please. Well, they owe a duty of care regardless. So regardless of whether or not they have actual authority, they're going to owe this duty of care with a business judgment rule presumption. But the question was, if they are given actual authority, do they have additional duties of care? Yes, based on agency law. So then at that point they're agents, and we have all the duties of care and duties of, we called them duties of loyalty and duties of performance. But there's a list of them, so we're going to apply those agency principles to them now because they have that actual authority. Yeah. And members can ratify an act which violates the duty of loyalty. And moreover, they can do more than ratify it. They can actually waive those duties of loyalty in the operating agreement. They do not have to owe those duties to each other. These are default rules. And since those are waivable, they're also ratifiable. Let's move across the ledger to the manager-managed limited liability company and see how they're different. They're going to operate more like a corporation. A corporation has a board of directors, and a manager-managed LLC has managers, sometimes even called the board of managers. They don't operate exactly like a corporation. I'll point out some key distinctions for you. The managers, or the board of managers, controls the LLC, and the members have essentially no control rights and fewer duties. Let's look at the governance structure. The managers control the company, and as a default, again, a default, you could change this in the operating agreement, each manager gets one vote. Now this starts to look like a board of directors. The board of directors, you get together, 3 out of 5 directors approves a course of action. Boom, approved. Similar here as a default rule. But in addition to that, each manager has the power to bind the company in its ordinary affairs. What does that mean exactly? That means if you're running that linen company we talked about in partnerships, a company that collects linens and cleans them and delivers them, we talked about things being in the ordinary course like buying detergent or buying gasoline for the vehicle, but not necessarily selling the vehicle and certainly not selling the business. In the case of a corporation, the directors on the board of directors have no power alone. Their power is as a board. The board has the power. The directors, the director, each director does not have power. The director cannot go on their own and buy more gasoline or enter into a contract to distribute linens. Not as a director, only as a board. Managers are different. Managers can. Managers are agents. Managers have authority to do that. They're almost like a combination of a director and a CEO or some other officer, and they have that right to bind the company. Ordinary course matters will be decided by a majority of managers, extraordinary matters decided by a unanimity of managers, and in addition to that, the members, while they don't control the company, they do get certain special rights to protect themselves. In the context of a venture-backed company, we would call these protective provisions, and there's a list of those. But they generally pertain to matters that a member would need to protect themselves from abuse by managers. Yeah, question, please.
What's the difference between each member being able to bind it and then it says that it needs to be the majority of the managers for the ordinary course? Is ordinary course different than ordinary matters?
The point I'm making in the, so the question was, I think, is there a distinction between the third bullet point and the fourth bullet point? So the third bullet point, the concepts are not, they're meant to illustrate different principles. The third bullet point is meant to illustrate that managers, qua managers, as managers, are agents, and they can bind the company. And they can bind the company in ordinary course matters. When there is a decision to be made about ordinary course matters, the fourth bullet point, when there's a decision to be made, that decision is made by a majority of managers. Now, if there's no decision, there is something to speak about here. So if a manager has reason to believe the other managers may not agree with something in the ordinary course, they want to buy Tide instead of Downy or whatever. They have some kind of preference for a particular brand of detergent, or they want to buy high-end detergent. They know that everyone else wants low-end detergent. If that manager has reason to believe there is good reason that there's going to be a dispute or disagreement, they don't then have the authority to go and buy that high-end detergent. They would have to go and have a meeting and decide, okay, we buy detergent in the ordinary course. Who votes for low-end detergent? Who votes for high-end detergent? 3 to 5, low detergent wins. Okay, now we have to buy low-end detergent. But in the absence of having sort of a reason to believe there's going to be a dispute, the manager can go out and buy detergent, can enter into a contract, can go about and do things in the ordinary course. So the two are not opposite. They just kind of relate to different principles. Good question. Thank you. Any other questions? Okay. Only managers owe the duty of loyalty and care we just saw in the previous slide, right? Those 3 waivable duties of loyalty, the 1 non-waivable duty of care, subject to the business judgment rule, to the members. In a manager-managed LLC, the members don't owe that duty to each other. The managers owe it to the members. And since managers are often, usually members, they also owe it to each other. And of course, they have that duty of good faith and fair dealing. Even the members have the duty of good faith and fair dealing. Why? Because they're all parties to a contract. And contracts have a duty of good faith and fair dealing. I call it a duty. I really should call it an obligation. I'm not even entirely clear how we distinguish between a duty and an obligation. But it really is more technically precise to refer to it as an obligation of good faith and fair dealing, as opposed to a duty of care and a duty of loyalty. Okay. Oh, voting rights, right. So one more point here on sort of governance structure. In a manager-managed LLC, we still need unanimous member consent. Member consent. So these are sort of those protective provisions we talked about, right? They can vote on special matters. When do we invoke the members? Well, to dispose of all of the property and goodwill, for example, basically to terminate the company, to approve a merger or other conversion, to undertake any act outside the ordinary course of the company's activities, and to amend the operating agreement. Again, amending the operating agreement can drastically change the rights of the members, and so you have a right to prevent that from happening. So we need their consent. Now, the operating agreement can, as a matter of how it's initially drafted, without being amended, it may not give them these rights. Many of these rights can be waived at the outset, and so you can sign up for an LLC agreement that doesn't give you rights to block a merger. Let's talk about authority in LLCs. Who has the authority? So we have authority concepts from agency. We know that managers are agents. We know members are not agents, and so we have to first apply those agency concepts. The actual authority of the managers is generally found in the operating agreement or a management agreement, but course of dealing and even potentially nature of being a manager may, where the operating agreement is silent, be another source of actual authority. But the operating agreement controls if other agreements conflict or if the course of dealing conflicts. The operating agreement is the central piece in understanding the LLC. If the operating agreement is silent, a default manager is authorized to bind LLC matters in the ordinary course. There's our default rule. If there are multiple managers, and this goes to your question, if there are multiple managers, one manager acting alone has the authority unless the manager has reason to know the other managers might disagree or that consultation is appropriate. And so that's how we get that difference between bullet point 3 and bullet point 4, where bullet point 3 is if sort of there's no reason to believe there's a disagreement, but if you think, hey, they might not like it if I buy Tide, maybe I should be buying Kirkland Signature brand, you have a duty to consult with your co-managers. They also have apparent authority. They're cloaked, as we say, with apparent authority to take actions that reasonably appear within the ordinary course. So here we look to what third parties know about the operating agreement. A third party could reasonably believe a manager has statutory, either from our LLC statute or from the operating agreement, or apparent authority even when the operating agreement provides otherwise. So it is important to look to the operating agreement, but if a third party doesn't have access to that agreement, it's a private document, it still might be reasonable for them to believe something which is not actually true. That's the point. That third party may reasonably believe something that's not true. They may reasonably believe there's authority because that person's a manager and because that's how things usually work. And so there is some duty to provide notice to these third parties if you want to expressly limit the authority of a partner, of a manager rather, because they may have apparent authority just by virtue of that's how things are done or that's what the statute provides. We have a Felborn Development Company when a manager entered into a debt and bound the LLC, even though he was not authorized to do that expressly, not actually authorized. Expressly not authorized to do it, right? It was like in excess of the amount. He was allowed to take out a debt for $600,000, it was like for $1 million. Okay. So in a member-managed LLC, in a manager-managed LLC, this is tongue twisters up here, yeah? In a manager-managed LLC, the members by default have no actual authority and they're not agents. Of course, they can specify otherwise. Whether they have apparent authority, again, is a question of agency law. Would it be reasonable for that third party to believe, based on a manifestation by the principal, the LLC, that the member has the authority to bind the LLC? So let's talk about liability. This is a limited liability company, but we do have some liability. There's a corporate doctrine called veil piercing, and veil piercing in LLCs is very poorly understood. The general concept in corporate law is that if you fail to respect corporate formalities, or if you commingle personal assets with business assets, or if you essentially run a company as your alter ego, if you essentially use the corporate form not for a legitimate corporate purpose, but only to avoid liability, to kind of shove the liability into a corporate form so you can go and engage in tortfeasing activities willy-nilly. The law has built a concept called veil piercing to not respect that. The concept of veil piercing in LLCs is much harder to get your head around because each LLC is going to be governed differently. But we try to generally graft on those concepts of veil piercing in the LLC concept. And there are just some general principles that we've looked at during our class that we applied here. We have a chart. But the general idea here is the LLC being used for a subversive purpose? Is this being used as someone's alter ego only to avoid liability? Or is this company engaging in legitimate business purposes. And one thing we might look to is, are there separate bank accounts? Is there a commingling of assets? This person's dipping their hand in the honeypot. We may not see them as being so separate. Single-member LLCs are one strategy some people thought they would apply to shield themselves from their own torts. That doesn't work. Why doesn't that work? Well, because the victim of a tort can sue either the tort committer, right? So let's say you can make a single-member LLC, which is a delivery company. So you're driving around, you're doing 90 on the highway, boom, you run into somebody. Think, okay, so that was in the course of my business. I'm not liable. I'm the member of a limited liability company. So where's the liability? Well, you also committed a tort. So it doesn't work for torts, but it does work for contracts. So a single-member LLC can be an effective way to prevent being liable for certain contracts. Another way what LLCs don't work for single members is for law practitioners trying to avoid malpractice liability. As a result, many states do not allow lawyers to form LLCs, and the ones that do require that there be liability for malpractice. The LLC cannot shield you from your malpractice liability. Even though that's not exactly a tort, simply not permitted. And so you don't see a lot of law firm LLCs. They're often LLPs or PLLCs, professional limited liability companies. And professional limited liability companies, they have that P at the beginning, which distinguishes them and lets the world know that that entity has some additional liability. So when we talk about liability, we have to have some kind of breach, right? We talk about tort liability. So what is the standard for tort liability in the LLC context? It's mere negligence, which is a very low standard. But we have this business judgment rule concept, and some states have a gross negligence standard. But it only takes negligence to be liable for a tort. And as a reminder, probably helpful for the bar exam, these are the levels of negligence. These are they're from negligence all the way. This is sort of the levels of culpability, would be a better way to frame the slide. The levels of culpability, ranging from being reasonable, which has no liability, to being intentional, which carries the most culpability and liability. So about that business judgment rule, the concept here is that questions of policy of management are best left to, again, it's a corporate context, to the board's honest and unselfish decision. So what is this? We create a rebuttable presumption that the directors or the managers or the members acted in reasonable diligence, exercised reasonable diligence, and acted in good faith. So it's up to the plaintiff to prove that they acted in bad faith, or that they were self-dealing, or this was otherwise some improper exercise of business judgment. In the corporate context, we see that come up when we had a case where there was an important merger that was approved in a 6-hour period and no one read the merger agreement. There wasn't enough process in place for the directors to be protected by the business judgment rule because they didn't show that they actually made a careful consideration. But in general, the business judgment rule is game over for plaintiffs. Unless it can be rebutted, that presumption is very strong. And so that really pushes back against that negligence standard. And the substance of this is directors are better than courts at making business judgments. All right. Our last section in this chapter is dissolution of limited liability companies. So let's briefly look at events that cause dissolution. They're all on this slide. I'll go into the next slides to provide some detail, but I just want to give you the landscape. This is sort of the roadmap for where we're going here. So when do events cause dissolution? Well, there are 3 events that are waivable, that if they're not waived, if these conditions are not waived, meaning if the operating agreement does not provide otherwise, these 3 things will cause the LLC to be dissolved. 1, an event or circumstance that the operating agreement states causes dissolution. When the members are paid back 3 times their investment, the company will dissolve and wind up. Sure, you can do that. On April 14th, 2015, the LLC will dissolve and begin winding up. Sure, you can do that. All the members can consent. Everyone gets together. We're done with this business. Okay. Start winding up. Or if there are 90 days during which the company has no members. And this is important because there can be ways that all the members can exit a company, and at that point there's no one to admit new members. The company at that point, of course, cannot exist, and so it can be sort of judicially wound up at that point in order to satisfy any creditor assets. But in addition to those waivable conditions, we have non-waivable conditions. You cannot change the operating agreement to get rid of these, and you'll see why. Because they protect members from unlawful and unreasonable practices. On application by a member and by entry of a court, a LLC can be ordered dissolved if, one, or A, the activities are unlawful, or B, it is not reasonably practical to carry on the activities. And on the other side, when you're talking about a managed LLC, there are additional grounds. If the managers that are in control of the company are acting in an illegal or fraudulent manner, then a court, on application by a member, can order dissolution and winding up. Or if the managers are acting in a way that is oppressive or harmful to the applicant, the courts can order dissolution or winding up. And these protective matters are granted by statute, and if they're in the statute, they cannot be waived by amending or changing the operating agreement. These protections are one of the few that really exist for members. Now, a court doesn't have to dissolve an LLC. There are less extreme remedies that can be taken. Dissolution is the most extreme remedy, right? The termination of that business. A court does have the authority to order a remedy other than dissolution. So it used to be that in partnerships, partners can be creditors to a partnership, meaning they can loan their own money to their partnership, but so can other people. You could have partner creditors and non-partner creditors. It used to be that partner creditors were by default subordinated to non-partner creditors. The thinking here was that partners knew more about the business, they knew more about protecting themselves, and it would be unfair to creditors that these partners who knew what was going on would interpose themselves as superior to them. But here we see that in our modern LLC statute, we no longer have this distinction. In fact, we see that in winding up activities, an LLC must apply its assets to discharge its obligation to creditors, including members that are creditors. So member creditors and non-member creditors are treated the same unless there's an agreement to the contrary, which, by the way, there often is. Often there is a subordination agreement when there are two different creditors. And that provision is mandatory. Again, why mandatory? There aren't many mandatory things. It's for the protection of outside people. So 708A is one of those few mandatory provisions. B through D are default, and you'll see why, because they protect the members. This has to do with how the surplus will be distributed. You satisfy your creditors, now what happens? So remember that debt is paid before equity, and members' interests are a type of equity, a type of ownership interest in the residual of a company. So you've satisfied your creditors, members and otherwise. Next, what happens is each person who has an interest that reflects their contributions gets paid back. This is similar in corporate law to the concept of preferred stock or investor stock. Preferred stock is called preferred because it has a liquidation preference, meaning when the company is liquidated, as in here, dissolved, winding up, and terminated, when a corporation is liquidated, certain investors get paid first, even though they're equity holders. First you pay the debt holders, and then you pay the highest preference equity holders. Same thing here, except the default is that the person that actually invested their capital gets that capital back first, and then if there's still money left over, then equal shares are distributed among members. That's kind of interesting. So you have a person who contributed $1 million, you have a person who contributed $1. Let's say the company has $2 million and $500,000 in debt. What happens? Well, first you pay the $500,000 in debt. Now you have $1.5 million. Then you pay back people what they were contributed, right? That's $1 million to one and $1 to the other. Now we have $999,000. $1 million to the person who contributed $1 million, $1 to the person who contributed $1, and now we split that in half. Each gets half. That's the default rule. You see why that's waivable. You may not want that. It's a matter between the members. If a limited liability company does not have sufficient surplus, any surplus must be distributed among the owners of transferable interest in proportion to the value of their respected unreturned contributions. Again, that preference concept, you pay people their investment back first, and all those distributions in B and C must be paid in money. Creditors can agree otherwise. They can agree to various kinds of relations, but remember that the creditor has to agree. So that 708A, the members cannot among themselves write in the operating agreement, we're going to pay ourselves before the creditors. Can't do that. Wouldn't make sense. But the creditors can agree. They want to give you a loan. Maybe they'll charge you a higher interest rate, you know. Some people are in the business of making very safe loans, and some in the business of very risky loans. We have mezz lenders, all different kinds of lenders in this world. All right, so that's how a company, an LLC, gets dissolved. Let's talk briefly about some of our case law in this subject. I have my notes on these here. Okay, so basically all of the cases relate to fiduciary duties, at least in some way. Maybe a little bit of authority in here. But Pappas v. Solis, this was about fiduciary duties here because we had one member who bought out another without disclosing certain things. Was there a duty to disclose? In solar cells, we have an investor and a company. The investor sort of takes advantage, and that was found to be improper. So we have a distinction. In Pappas v. Solis, we let that transaction stand. In solar cells versus true partners, we rescind that transaction. Why are they distinguished? Okay, VGS versus Castle, we have another situation where we have various equity holders. They enter into a number of relatively complicated transactions, which are described in some detail here. We have a board member who sort of moved around, shifted sides, and sort of like a coup. And we had some issues here about whether or not that manager was able to sort of vote against the member who appointed him. He was not in this particular fact pattern. Professor Joshua Furshey has a really excellent explanation about this case you should look at. In Racing Investment Fund, I use this case mostly to discuss what is a capital contribution or what is a capital call. In the matter of Ocean Avenue, we have two individuals who both control a company, right? And when you have two people, what's a majority? Everyone. And the ordinary course was to build a house. One was a building company. We had an issue about dissolution here, so there's some complicated facts, a stop work order that may have been ineffective, so some facts there that had to do with control as well as dissolution. The only basis for dissolution can be that the LLC cannot effectively operate under the operating agreement to meet and achieve the purpose for which it was created. And finally, in the matter of Arrow Investment Advisors, I'll read the long quote here. This is sort of the point, the final point about dissolution. The court will not dissolve an LLC merely because that LLC has not experienced a smooth glide to profitability, or because events have not turned out exactly as the owners envisioned. Such events are, of course, common in the risk-laden process of birthing new entities in the hope they will soon become mature, profitable ventures, in part because a hair-trigger dissolution standard would ignore this market reality and thwart the expectations of reasonable investors that entities will not be judicially terminated simply because of market turbulence. Dissolution is reserved for situations in which the management has become so dysfunctional or the business purpose is so thwarted that it is no longer reasonably practical to operate the business. Excellent. That's Module 3. Thank you very much.